Indiana's third grade reading scores show improvement. A judge dismisses a lawsuit over a higher education law, plus a new statewide water study, and more. From the television studios at WFYI, it's Indiana Week in Review for the week ending August 23rd, 2024.
Indiana Week in Review is made possible by the supporters of Indiana Public Broadcasting stations.
This week, Indiana students made small gains in reading this year. Indiana Public Broadcasting's Kirsten Adair reports scores for iRead 3, the state's third grade reading exam, are at their highest level in recent years, but still well below pre-pandemic scores.
The overall pass rate increased to 82.5% this year. That's still more than 4 points below pre-pandemic levels. But Indiana Secretary of Education Katie Jenner says the 0.6 percentage point increase over last year's results shows the state's interventions are working.
It is exciting to have the highest year-over-year increase ever in the history since the start of the test.
More than 14,000 third graders still failed the test, but the Indiana Department of Education says many of those students could be eligible for exemptions, so they won't have to take the test again. Some student groups saw modest score increases. Black students saw the largest, 3 points higher than last year. Students in special education and students receiving free or reduced lunches saw increases as well.
Are the iRead scores evidence that the state's efforts are working? It's the first question for our Indiana Week in Review panel. Democrat Ann DeLaney, Republican Mike O'Brien, John Schwantes, host of Indiana Lawmakers, and Leslie Bonilla Muñiz, reporter for the Indiana Capital Chronicle. I'm Indiana Public Broadcasting State House Bureau Chief Brandon Smith. Mike O'Brien, 0.6 percentage point increase. Doesn't sound exciting, but is that exciting?
It is exciting. I mean, it's going the right direction. It was going the other direction before, so if you net it out, it's not just 0.6. We didn't drop.
Yeah.
You know, it's not getting worse, and turning that corner was really important. And look, I mean, this is the first third grade class that's really truly like post-COVID when they started their education. So it should continue to go up. And look, the state, the legislature put hundreds of millions of dollars into post-COVID education dollars to help kids catch up that maybe didn't have access to virtual learning or a sporadic access to virtual learning and fell behind during that period. And so this is the direction these numbers need to go. 0.6, maybe it's not knocking your socks off, but we'll keep moving in the right direction.
I mean, 0.6 percentage point, yeah, 0.6, it's 6%,
yeah,
6/10.
0.6.
It doesn't sound like a lot, but at the same time, it's also the highest increase year over year in the 11 years now that this exam has been taken by students. Is it, I'll go back to the first question I asked, is it proof that what the state is doing so far is working?
I think it's a positive thing, okay, I'll grant you that, but it's important to recognize, yeah, that's all you're going to get.
The 0.6%.
But I think it's important to realize that at this rate, it'll be years before we're going to be back where we were pre-pandemic. And where we were pre-pandemic was nothing to brag about. So it's important to keep this in perspective. Yes, they put money in it, and yes, that's a good thing. But if they'd stop screwing around with education, if they'd stop with the diplomas and the charter schools and the voucher and all the things they've done to screw up the educational process in Indiana and focus. I mean, if those kids come out of third grade not knowing how to read, all the rest of that's garbage.
Yeah, they agree.
It has no impact.
Yeah, they agree with that. Yeah. Well, to that end, we've seen, now I don't think what lawmakers have done very recently on reading necessarily is showing up yet, because so much of that is still to be implemented, whether it's the science of reading or the stuff they just did on holding kids back in the last session. But are these test scores, again, now I think it's 3 years in a row going in the right direction. Is that enough for lawmakers to maybe this upcoming session go, okay, let's let all the stuff we've been doing the last couple of years play out a little more before tinkering with it again? Do you think it's enough to get them to hold off essentially on more changes?
I mean, something that Secretary Jenner mentioned is that some of the teachers who are already trained in science of reading during, the year that the iRead test was taken, saw pretty big improvements in scores. I think my colleague Casey's reporting was that some classrooms saw 20% jumps in scores. And so, maybe as more teachers finish the training, like maybe, who knows, like where that could go. But like science of reading, training in that is just one factor that goes into how the scores shake out.
And then, John, same question. Do you think the slow but steady progress here these last few years is enough for lawmakers to go, okay, let's let the things we've already done play out a little more before we
I think they almost
Like
have
they've
to. I'm
always done in
not
the
sure what
past.
else they could do to tweak it at this point. They really, well, I should take that back. There are always ways to tweak things, I suppose. But I think that's going to be the instinct because of the pattern of improvement. I think the point that Leslie makes is a good one about the cadre, the state program that offers training and instruction for teachers in the science of reading and teaching reading. As you point out, average, I think, was less than 1%, far less than 1% among schools that aren't participants in that program. The increase, I think, was 0.02, 0.05 something, versus that 2+ percentage point increase for schools where those teachers have had access to that education. Yeah. I think, let's remember though, before we celebrate, I always sort of the wet blanket here. If this were an investment portfolio and say, let's use thousands of dollars instead of percentage points, you'd say, oh, good news, I'm your financial advisor. Brandon, I got you up to, $82,600. And you're going to respond, yeah, but when the first year I came with you and joined your services, you were at $91,000. Yeah. Well, how come I'm not at 90, which was the first year of the test for the 2012, 2013 year, was a 91% pass rate. So we got to keep that in mind. COVID, no one could have anticipated. It was an incredible blow for us and the rest of the world. Let's hope that at some point we can get back to those levels. We won't get, I think the Holcomb administration had set a goal of 95% pass rate by 2027. Chances are that's not going to happen.
That seems like a long shot. I also can't think of anyone around this table I want to be my financial advisor less than you, John.
Yes. I can lose that much money for you. Yes.
All right, time now for viewer feedback. Each week we pose an unscientific online poll question. And this week's question is a 0.6 percentage point increase in third grade reading test scores worth getting excited about? A, yes, or B, no. Last week we asked you whether addressing property tax bills should be the top priority for the governor and lawmakers in 2025. I like the results of this one, they're interesting. 54% say yes, 46% say no. I would like to live in the place where the 46% live. If you'd like to take part in the poll, go to WFYI.org/IWIR and look for the poll. A federal judge recently dismissed a lawsuit challenging a controversial new state law that university professors say violate their constitutional rights. WFIU's Ethan Sandweiss reports.
Senate Enrolled Act 202 requires faculty to include a variety of opposing political viewpoints in the classroom or risk losing tenure protections. The American Civil Liberties Union of Indiana is representing 4 Indiana professors who say the law violates their First and 14th Amendment rights. Indiana Attorney General Todd Rokita, who intervened in the case, says the law will foster diversity of thought. He says the suit should be dismissed because the professors have not been harmed. Judge Sarah Evans Barker agreed that the plaintiffs' claims, quote, are not ripe. In other words, the professors need to show that their constitutional rights have already been infringed. The ACLU argues that's already happening. The very threat of punishment, it says, is already causing professors to censor themselves. Barker cited a 2013 U.S. Supreme Court ruling that, quote, respondents cannot manufacture standing by inflicting harm on themselves based on fears of a hypothetical future. The ACLU of Indiana declined an interview, but said in a statement it is considering other options to challenge the law.
Ann DeLaney, is the fight over this lawsuit behind us?
Oh, not at all. I mean, the law is unconstitutional, and all Judge Barker said was that she needs a real controversy in front of her to make a decision. I hope it's a shot across the bow for the universities, saying it's coming back if you try to implement this in any way or try to penalize those who don't subscribe to the half-baked conspiracy theories of the magna part of our population. I mean, they're not going to be teaching things like creationism and the rest of that in the schools, and shouldn't be. And I think the schools would like to back away from this as well. I mean, the fact that this bill was authored by a Purdue employee is a disgrace, frankly. And I think he's probably not going to be invited to too many faculty teas or cocktail parties by the professors. It'll be back if the universities don't use common sense and not implement it. It'll be back.
To that end, what message do you think this ruling sends to the universities? I mean, they won, but is it a win?
is a short-term win. I mean, I think this idea that you have to compel diversity by law in diversity of thought in classrooms is really complicated. And it's also, on all of these issues, whether it's banning books or whatever, creating these, all these different areas where we're trying to kind of force thought or force exposure to ideas. I think back to my college experience. I went to IU as a political science graduate at IU. Patrick Sellers was my Congress professor. And he was, if you don't know who that is, he was Tom Dapple's chief of staff when he was the Senate Democrat leader. So I never walked into Congress class every day thinking I was going to get a diverse, unbiased perspective on what Congress did that day, or did the day before. But that's also
look at how liberal he's made.
I know, but that was all. Well, some would argue. But that's also my job, kind of as a student, isn't it? To go in there and go, look,
push back.
I walked into. We treat these kids like they're idiots, like they're just being fed stuff, and they're not fed the thing we think they should be fed. Then they're going to go off and do things we don't want them to do. And I don't remember my college experience being that. I remember walking into these, constitutional law classes and Congress classes, and these things where, things are being said. I'm like, I don't agree with that. That's the point. That's the whole point. And we've lost the responsibility of the student in this too. And we make them just look like they're just these hapless victims that are getting dropped into these factories of liberalism. And I'm just tired of it.
I want to ask about one part of this lawsuit that is interesting to me, which is that, so the professors sued the universities because the universities are the ones who really enforce or implement this law. But the Attorney General's office, as would make sense, stepped in to defend a state law, as they do in any case, or just about any case. And Attorney General Rokita's office, in its brief, said, anything a professor says in a classroom is government speech. The universities tried to back away from that opinion as fast as humanly possible, but does that raise questions about how this law and others like it will be enforced going forward?
Sure, there's confusion, and in fact, the university, I know IU has put out a deck of slides along with the faculty council and others and the VP for faculty affairs to deal with these very real-world questions. It's almost like you'd see in a freshman orientation. What do I do to get from Ballantyne Hall to, in this case, it's aimed at faculty. It's like what is acceptable and what is not. So they understand there's certainly confusion. But the notion that it's government speech, that's fantasy. I mean, this was not a ruling on the merits of the case. This was simply about standing.
Right.
And for the Attorney General to suggest otherwise, well, it's never stopped him before. I mean, he sees he can make hay here. One thing I would point out, and you've referred a couple times to the universities being winners at this level, the suit is against the trustees, which are increasingly not representative, it seems to me, of the core of the universities they purport to represent and govern. I would say that there are plenty of people in the university, even in the senior administration, who didn't see this as a victory. Yeah, it might have been a on paper, lawyer to lawyer.
It's just
but this
postponement is all it is.
I agree with you. I agree with you. But I think there are many in the faculty who would have, in the administration who would have said, I wish they had ruled on the merits because I think it'll go
our way.
And it would have resolved the issue. So when we say who the winners and losers are, it's always going to be ticklish dealing with this particular litigation.
I will say, I'll essentially ask you the same question to this one that I asked on the last one, which is from a legislator's perspective, we know that the legislation that lawmakers passed last year didn't appease all Republicans who are increasingly unhappy with leadership at higher education and professors in higher education. But does this lawsuit, going certainly their way for now, in that the law is intact as is, does that postpone any further action they might otherwise take?
Listen, there's a couple of months between now and January, and it's a long session, so there's plenty of time for them to stick something into a vehicle bill. So I'm not really sure. It depends on what happens next. It depends on how quickly universities finalize their policies and put them into place, and how soon we see enforcement actions being taken.
What's the real example?
If any enforcement actions.
Yeah.
And the fact that Rokita says it's government speech is worth exactly the powder to blow it to blazes.
The LEAP pipeline project has created a tug-of-war over the water supply in Tippecanoe County between residents there and those who want to create an industrial district in Lebanon. Indiana Public Broadcasting's Rebecca Thiel reports the Indiana Chamber of Commerce says conflicts like that show the state needs to start water planning now.
A new report by the Chamber says there's plenty of water in Indiana right now, but with central Indiana growing and proposed development in other parts of the state, there may not be enough to meet demand in the future. Jack Whitman is a hydrologist with Intera, which helped prepare the report. He says Indiana has been slowly working to complete regional water studies, but the LEAP project has shown the state needs regional and state water plans.
So it helps us see what other things can we do to make sure that we already anticipated these questions and we're ready with information and data.
Among other things, the Chamber recommends putting one team in charge of state water planning, better monitoring Indiana's water resources, and funding water research.
Leslie, can the state really prevent regional water fights in the future?
We're already in the middle of a water fight. It's already begun. And I think that even trying to put a policy onto paper would be a fight in itself. But at the same time, these are things that can be short-term skirmishes. If they can battle it out and get something on, into code, then maybe that could prevent or at least create a structure for handling this, which the Chamber and many others have noted is likely to be a pretty long-term issue. So maybe.
How much will this first real water battle, which is playing out between Tippecanoe and Boone County and this LEAP district and folks up in Tippecanoe, whatever the resolution of that is, and we don't know what it is, the state is still doing a study on that specific issue in those specific areas. Whatever the result of that is, can that be a blueprint that can prevent more fights like it down the road?
One would hope. As has been noted, Indiana does, the experts say, have sufficient water supplies now, which is great. Think of the states that would give their IT
to be in that
position. So let's hope that that's the case. But, water is one of those things, you almost have to take a regional, holistic approach. We see it we're talking about something that would be at the statewide level, but look at water issues where it's multi-state compacts. You look at southwestern part of the United States, the Colorado River, where those states are fed by that. It wouldn't matter if Arizona did one thing in California. There has to be some collaboration, just as the purity of the Great Lakes and the quality and keeping the carp, the dangerous non-indigenous carp out of there. It wouldn't matter if Indiana did one thing. And so, because water doesn't have a way of stopping at the state line, whether it's a free-flowing river or whether it's in the water table underground. It doesn't, there's no barrier. The wall, as far as I know, nobody's built the wall between.
By God, we'll crack that, yeah.
And make the water pay for it.
I agree with that point. I agree that it feels like it has to be a collaborative regional thing. But now you're going to have the problem of the state being the one, which would make the most sense to try and facilitate that against locals who say, hey, you have no real authority here. We're going to do what we're going to do with our water, and somebody else is going to figure it out somewhere else.
But it's not their water.
Yeah.
It's water that happened to. It's a good thing the county to the west of Tippecanoe County didn't decide it was their water.
Yeah.
And now it's not flowing into Tippecanoe County.
Right.
It's an absurd. This whole experience has been absurd since this first came up. Tippecanoe County can't say we have 25 million gallons more per day of water than we need, and you can't have it. That's not a thing. That's not a role of local government. This has to be managed. This has to be managed statewide to the benefit of all Hoosiers. The state was never going to take 20 million gallons a day out of Tippecanoe County, and then they were going to not have water anymore. We weren't creating a water crisis. We were solving another one. But this is because the state legislature has neglected to, and hasn't needed to really until now, step in and really put a statewide framework in place, like so many other states have done. This isn't like a Republican-Democrat thing. It's like only liberal states manage their water well. It's like this happens all over the country, but it's got to happen at a statewide level. You can't have your town councilman deciding where water's flowing.
And yet, so much of the discussion, because of the LEAP district and focused at this point more so on economic development, has been too much of this state-led, top-down approach. We have to stop doing that and empower local communities more and more and more. That would seem to be in conflict with what's needed in this water conversation.
You have to have a statewide structure set up. You absolutely have to. And you have to have a way of arbitrating between these groups. Used to be when you had factories with big water demands, like coal companies, for example, they located by a river. Now they want to locate wherever they want to locate or where the quality of life is better. Okay, fine. But that means that we have to take a different approach to water than we used to. And the state is the only entity that can come in and set up a structure and set up a means of resolving disputes that are inevitable.
Well, it's not the only one. There is the federal government, which arguably...
Well, they're not going to worry about Indiana.
I know, that would strike fear in the heart of...
Well, they're not going to worry about Indiana.
I didn't say it's realistic.
To the idea of, though, like locating where there is water, I mean, I think that's something the Chamber pointed out, is like there's a huge, largely untapped water source in southeastern Indiana where there isn't right now a lot of stuff going. Hey, maybe some stuff should go there because it makes sense to put it there.
Northern Indiana, too, is water rich.
Or move the water out of there. But then that gets pricey. And that's part of the problem. All right, school attendance is improving for many Indiana students, according to recent state data. From WFYI's education desk, Dylan Piers-McCoy reports the gains come after a surge in absenteeism in the wake of the pandemic.
The number of Indiana children chronically absent last year was about 18%, according to recent data from the state. That's better than the previous school year. It's the second year in a row that Indiana has modestly reduced the number of students who are missing way too much school. Carolyn Gentle-Janety of Butler University is an expert on absenteeism. She says the state's focus on school attendance is paying off.
Schools are doing their part, the state is doing its part, and parents are learning or understanding that their students do better when they're in school.
Indiana schools have used lots of strategies to improve attendance, like regularly notifying parents of how many days their children have missed, and holding attendance conferences with families.
John Schwantes, this statement may be disagreed with by some of our panel, but in my view, lawmakers didn't do a ton in the way of absenteeism legislation this past session. Certainly not the sort of things it sounded like they were going to do when the session started. But they did send a message, certainly, if nothing else, that they wanted schools to focus on this problem, rightfully so. Does this sort of progress, it seems like this is the theme for the show, does this forestall further legislation?
Yes, this is enough, I think, to keep it off the table. And in a realistic event, you were alluding to difference of opinion about what was done and wasn't done. You're right, it wasn't any kind of draconian action that had been discussed early on, where every parent was going to be serving life sentences for promoting their kids' tardiness. Well, in some count, yeah. So,
well, now that we've got the death penalty drug back.
Now, make it's more affordable and all that good stuff. But so there are mechanisms by which parents are notified, or guardians, I should say, if it's a certain trigger, maybe 5 days. And there is actually in that statute that was enacted, took effect in July, just last month, that there is mechanism for a referral or notification, at least, to local prosecutors who could, if they wanted to, and no one's going to want to, so don't get alarmed, start the criminal proceedings. I mean, unless it's an egregious case of neglect, to start something about promoting tardiness or failing to keep your kids in school. But the upshot of all of that is, hey, we just passed this, whether it's a hefty law or a minuscule law, it's just taken effect. So let's see what happens, especially since you have a trend that's suggesting that it's moving in the right direction.
Yeah, to that point, I mean, the notification part, which is the newest thing in that legislation, a lot of the legislation kind of reinforced what was already on the books. But that notification piece, how important can that be in trying to curb this problem?
I mean, it's certainly a difference, but, with actions like that, I kind of agree with your point that, might as well see, what happens before you make some more changes.
Lawmakers were really focused on this heading into the last session, and rightfully so. Some of the data they'd just gotten was alarming. In some rural schools, 1 out of every 2 kids was considered chronically absent. That's you talk about if they can't read after 3rd grade. Well, if they're not there in the first place, that really creates
problems. It does interfere with their ability to learn.
But I mean, this kind of data, is it again enough that the legislature can go, okay, let's let them keep doing what they're doing?
I think so, because I think the mechanism of basically calling the parent or guardian in when it's 5 days sends a pretty chilling message, because it's not simply criminal prosecution, which is probably very unlikely, but they could also institute a Chins petition. And arguably either take the child out of the home. And that can be really have an effect on making the parents seem to be better stewards over the attendance of their children.
And some of this is down to the schools themselves and what resources they have, but it feels like they are focusing more and it is working.
Yeah, and let's flip the conversation from the last segment on its head and say this should be local. This should be the school doing this, not the state. The state's setting the standard, but the locals are the local school districts have to enforce it because
understand the individual situation.
Yeah, and understand why.
Right.
Why is this happening?
What's going on? Yeah.
All right, that's Indiana Week in Review for this week. Our panel is Democrat Ann DeLaney, Republican Mike O'Brien, John Schwantes of Indiana Lawmakers, and Leslie Bonilla Muñiz of the Indiana Capital Chronicle. You can find Indiana Week in Review's podcast and episodes at wfyi.org/IWIR or on the PBS app. I'm Brandon Smith of Indiana Public Broadcasting. Join us next time because a lot can happen in an Indiana week.
The opinions expressed are solely those of the panelists. Indiana Week in Review is a WFYI production in association with Indiana's public broadcasting stations.